In November of last year is when the city received this subpoena. Your Honor, I never heard back from Mr. Miller ever again on this case at all.
Mr. Miller, how come you didn't respond to Ms. Linskog when she reached out to you?
And Bethel also on this meeting?
Yes, and my husband Scott's right here with me, her
Okay,
father.
generally, we don't wear hats in a courtroom proceeding, sir. Thank you. This matter comes before the court at this time, apparently for further hearing in regards to an objection to subpoena that was lodged by counsel for the city of El Dorado. Court has before it the subpoena of business records, which I think is involved. It was one to the El Dorado Police Department custodian of records, essentially a attempt to subpoena business records from the city of El Dorado. I will note that it's improperly captioned. The caption of the subpoena is KN Bethel petitioner versus state of Kansas respondent. Is that a separate case?
It's not, Your Honor. She is the administrator of the estate, and it should have said administrator of the estate of Tori Bethel. So the caption is incomplete. Yes.
All right. And the state of Kansas is not really a party to the case.
That's correct.
All right. The city of El Dorado has filed an objection to the subpoena. Mr. Miller, I know that you're familiar with it and its rationale. What is your position today regarding the objection that's been filed by the city of El Dorado?
Judge, I would obviously the estate was opened for the purpose of investigating the circumstances surrounding Tori Bethel's death. And we asked for the investigative files. Obviously, her death was the subject of a law enforcement investigation. My understanding is that investigation has been completed, and that the city is objecting based upon the fact that these criminal record or the records of the criminal investigation are protected by the Kansas Open Records Act. Again, I think the investigation itself has been completed. There's certainly, we've done a limited investigation thus far, indicating that while the investigation may have concluded that Miss Bethel's death was, there was no foul play involved, there certainly, I think there's a reason to, based upon the autopsy and other material that we've gotten, indicating that in fact it may have been foul play that was involved. So I think those records, the criminal investigative records, are relevant to that investigation. And I suppose if, depending on what the court rules today, if we need to file an actual petition under the Kansas Open Records Act, that may be something that we, may need to do following today's proceeding. But I think these records, I was involved in a case where there was a suspicious death here in Sedgwick County, at the Sedgwick County Jail. This is the procedure I followed: opened up an estate, issued subpoenas, and received the law enforcement videos, the entire investigation, even from the KBI. So I'm not sure that I'm precluded from getting this investigation or the material from this investigation pursuant to a subpoena. I certainly think there's relevant information there. Again, going to the whole purpose for why the estate was opened, which is to.
Well, let me ask you about that,
Sure.
Mr. Miller. Does the Kansas Probate Code contemplate that estates would be open purely for the purposes of conducting investigations?
For a special for a special administration, absolutely. And we cited in the petition, we cited the subsections that allows for a special administration for specific purposes. And this specific purpose is to at least potentially litigate. And there could be a number of causes of action here. Wrongful death, there could be causes of action against, the city. But that's the purpose for why this estate was open. The special administration was open. And I think the subpoena is asking for relevant information. Again, if the city is concerned about confidential information being disclosed, there's certainly there's procedures that we can take. We can do a protective order or an in-camera review by the court. I mean, I think there's potentially a lot of avenues open here other than just quashing the subpoena. One of the other objections made was that we did not advance, any fees for the production of these records. And I mean, we're happy to pay whatever production costs or fees that are associated with that. It's just, I don't know what those costs or fees are, and that's never been communicated to me, but that would be our position.
Ms. Linscott, why shouldn't the city of El Dorado just be required to turn over these records?
Yes, Your Honor, if I may, and you have to bear with me a little bit because I think some context is important here, Your Honor. So back in November of last year is when the city received this subpoena. It's city policy, especially when we get requests for investigative records and all of those things through something like this, to sort of work with the person requesting them to understand what the point is, what specifically they're looking for to protect the investigation as a whole. At that point in time, we filed the motion to quash and then immediately served a copy on Mr. Miller. And I reached out and said, hey, let's talk about, let's find a way to connect over this, and not in a way to say this, you're never going to get anything, but in a way to say, let's figure out a way to get you what you need or whatever under a court order or any of those things to protect the information in the investigation that we might think is confidential through the mechanisms in which Mr. Miller identified. Your Honor, I never heard back from Mr. Miller ever again on this case at all until, and it sort of fell off my radar because I filed the motion. No, nothing was set for hearing, nothing happened. I followed up again, I think, and then it sort of fell off my radar. And then maybe a month ago, the city of El Dorado received something like 60 to 70 Cora requests for this information. And I understood that that was a result of a Facebook group that Mr. and Ms. Bethel had requested that everyone go on and ask the city for these records. I responded to all of those in the same way. And I know that Ms. Bethel has gotten a copy as well that said, hey, working with counsel to try to get you the information that you need. But I think that there's a miscommunication here because I'm not at all attempting to block access. I'm merely trying to get some mechanisms put in place. But at that point in time, I understood that the Bethels were represented by counsel, so I couldn't reach out to them individually. So I again reached out to Mr. Miller and said, hey, I think there's been a miscommunication here. I'd really like the opportunity to get resolution and to get your clients what they need, but I'd really like a court order based on a lot of concerns that we have. Those concerns being is that this matter has had a significant amount of social media attention. And so we've gotten complaints from people who were involved in the investigation early on that the Bethels had hired a private investigator who have been harassing some of the people involved in the case to the extent where the police have been called. I'm not suggesting that harassment has not occurred. I'm just giving you context as to why the city was concerned about just carte blanche releasing all of these investigative records. So then I again reached out to Mr. Miller and said, hey, I have concerns about this. I can't reach out to your clients directly because I understand they're represented by you. I'd like to get resolution. And Mr. Miller advised me he's withdrawing from the matter. And I got no further instruction one way or the other. At that point in time, Judge, is when I asked for this hearing because I did not feel like I could adequately communicate this information to the Bethels. I couldn't get adequate communication from their counsel. And so I thought, you know what I'm going to do? I'm going to notice this up for hearing. I'm going to explain to the court what it is specifically that we're looking for because the city of El Dorado is not trying to stand in the way or the police department of getting these people the information that they want, but it needs to be done in a way that we can protect the information or those involved and keep them from either being harassed on social media or have people calling them or any of those types of things. So the city's position at this point is that the Bethels have been sat down with Detective Roberts, who was the one investigating the case, and have been granted ample opportunities to go through the information, get the information that they need, but specifically what it is that they're looking for, what it is that we can help facilitate, whether we do an in-camera review and allow them to come into chambers and review the investigative file, but we are asking that the court order that we redact any names of anyone that was involved in the investigations to protect those individuals, especially in this situation where it was ruled that the through the autopsy that there was no foul play, that the investigation itself didn't result in any sort of further criminal investigation. So the point, Your Honor, of noticing up this hearing was to just get the parties on the same page, since I was having significant trouble getting through to anybody on the other side. And the narrative, I thought, was just unfortunately incorrect.
Miller, how come you didn't respond to Ms. Linscog when she reached out to you?
Judge, to be honest with you, this case sort of fell off my radar as well. And I know the excuse of caseload and so forth. I've had couple of murder trials in between. And so that's my fault. I should have reached out and had better communication, certainly with the city. So I take responsibility for that. And I'm certainly willing to sit down and discuss it, in whatever way we need to. So I do take responsibility for not being in better communication. There was some issues at some time about whether I would even continue to be counsel in this case. But those issues have been resolved as well. But I guess, Judge, I do take responsibility for not being in better communication.
Right.
And I'm willing to, sit down and go over in whatever way the court directs, whether in camera, protective order, what have you, and try to get the information that we're seeking.
Well, I'm inclined to be deferential to Ms. Linscog and her position here, that apparently the city is willing to work with the estate in releasing certain information from records in their possession under certain conditions. This is probably something that the court should allow counsel to actually discuss and see if there can't be an accord reached regarding what's to be disclosed and under what conditions they're be disclosed. But one thing that I'm going to caution counsel about is somehow dumping these into the lap of the court for in-camera inspection. There is just a special administration pending. No tort case, no criminal case. There's no context for which this court can make any determination what's relevant and what isn't. Because quite frankly, I don't even know what the estate's looking for here. For what purpose are they wanting access to these records unless the family members just want to know what happened to a loved one, or haven't gotten an explanation regarding the apparently tragic death that took place in this case, which the court can certainly understand. But with that said, I think that the court wants to give counsel the opportunity to reach an agreement on this before the court gets involved in it. For now, the court will sustain the objection, subject to counsel conferring to see what agreement might be reached regarding either partial or full disclosure of records and under what conditions. One thing that I'll just throw out as a possible solution to the problem is that in similar situations, the court has allowed disclosure or compelled disclosure, but for counsel's eyes only, with an admonition that you can discuss the contents of the documents under whatever conditions are proper with the client, but the records are not to be released outside the attorney's office. That way they can't be disseminated to the wrong people for the wrong reasons. And it also, in many instances, protects the personal privacy of certain people involved. Redaction was mentioned by Ms. Linscog. That very well may be appropriate. On the other hand, I suspect that that's just those names may be the exact information which are being sought in this case, and redacted records may not do them any good. But again, this is a subject which I think counsel should at least intelligently discuss with one another in good faith and just see if an agreement can be reached.
Yes, Your Honor. I'm sorry, Judge, I didn't mean to speak over you.
Go ahead.
I would just request, and I understand getting busy and things have fallen off my radar before, but in order to move this matter along, can we set this matter for hearing 2 weeks out or 3 weeks, whatever Mr. Mill might think that he needs as a backstop, as a mechanism to get resolution? And I only ask that because it can sometimes be hard to get this matter moving, and I just don't want it hanging or the Bethels left thinking that the city is dragging their feet here.
All right. When do you believe you're going to have the opportunity to confer with Mr. Miller?
I'm happy to confer with him right now, Your Honor.
Okay, well, quite frankly, I'm willing to keep this meeting open so that you can use this Zoom meeting to do an initial conference. Obviously, the court would leave the
Sure.
meeting at that point, and we'd go off the record, but I'll offer that.
Mr. Miller, do you have time for that?
I do.
And
All right.
could we not also have it broadcast, Your Honor?
It's not going to be broadcast or recorded.
Okay, and Detective Roberts, can you stay on the line for us too? And then we can maybe just have a conversation about what we need to move this thing forward and get resolution. Judge, thank you so much for that opportunity.
So Roberts, you still with us?
Yes, sir. I'm still here.
Okay. Let's go ahead and set that date as a precautionary measure.
Yes, Your Honor.
Perhaps an agreed order will be submitted to my queue before then.
That would be fine, Your Honor. I know,
certainly encourage.
I think we could probably agree on a date. Let's go.
Judge, do you have a date or a time 2 weeks out, or is Mandy still on here? Do we just mark it
I
down?
have my calendar.
Okay. Let's see. I'm completely open on May 23rd, Your Honor, if you have any time that day.
Mandy, can we still do 3 o'clock?
Judge, oh.
No, we have something set there. We have
Okay.
an 11 o'clock open.
Okay.
Sorry, that date I'm in a murder trial here in Sedgwick County. What about, would the 16th, would the court have anything on the 16th? That'd be 2
That
weeks.
is barely 2 weeks. Actually, I'm scheduled to be in jury trial then.
Okay.
And it's anticipated it's going to be a homicide that it's going to go. So.
And, you know, I also have to take my kid to the zoo that day, so the judge and I are very busy.
Extremely
What about the
important.
30th? Would the 30th be available, or
4 o'clock.
I could do that?
Works for me, Your Honor. Thank you so
Alright.
much. Thanks,
I'll
Mandy.
set further hearing if needed
Thank you.
in this estate matter for Thursday, May 30th, 4 o'clock p.m. by Zoom.
Thank you, Your Honor.
Thank you, Your Honor.
And I will ask Mandy to stop recording and broadcasting at this time.